Sometime around the year 1608, in a chamber at Whitehall, the King of England lost his temper with a judge. The king was known in England as James I, also known as James VI of Scotland, who had come south 5 years earlier to take the English throne, and who had arrived already the author of his own book on the divine right of kings. He was learned and he knew it. And on this day, he advanced a claim that followed directly from everything he believed about his own office. His judges, he said, were merely his delegates. They held their commissions at his pleasure. The law was founded on reason, and he, the king, possessed reason as fully as any judge who ever sat on any bench in England. So why then could he not take a case out of judges' hands and decide it for himself? He was the sovereign. Why should he not judge? It was not, on its face, an unreasonable question, and the man who had to answer it was the Chief Justice of the Court of Common Pleas, Sir Edward Coke. Coke did not deny the king's intelligence. God had endowed His Majesty with excellent knowledge and great natural gifts, he said. But, and here the whole coming century turned on a single word, but. His Majesty was not learned in the laws of his realm of England. And the matters that came before the courts, the matters touching the life and the property and the fortunes of Englishmen, were not to be decided by natural reason. They were to be decided by the artificial reason and the judgment of law, an art that takes a man long years of study before he can master it. The king had reason enough. What he did not have was the law. James understood the insult buried in the courtesy at once, and he was, by Coke's own account, greatly offended. If this were true, the king said, then he should be under the law, and to affirm such a thing was treason. And here Coke did not retreat. He reached back 400 years to a maxim from the old medieval jurist Bracton, the sentence that would become the motto of everything the English common lawyers were about to attempt: that the king ought to not be under any man, but under God and the law. A judge had told a king to his face in the king's own presence that the king was not above the law. Now, caution, because with a new chapter, we should be honest about our sources. Nearly everything we know about that scene comes down to us from Coke himself, set down years later in his own reports and published only after his death. He was the hero of the story he was telling. The exact date is disputed. Scholars place the meeting in 1607 or more likely in November of 1608. The precise words, the drama of the room, we should hold that all loosely. But the constitutional proposition that survives in that report does not depend on the staging. The Chief Justice of the Common Pleas had drawn a line around the throne and had declared it that even the crown stood inside of it. That line, that single contested revolutionary proposition, is where the English road to 1776 begins in earnest. This is episode 8 of the series, Self-Evident, The Road to 1776. And today, yes, the common law will control. This episode corresponds to Article 8 of our written series, published this past Sunday on our Substack page. And it opens a new arc I know a lot of you have been waiting for us to get to. For the last 3 episodes, we have been on the continent with Luther at Worms, with the Calvinist theorists who reasoned their way to the right of resistance, and with the Dutch, who took that theory and built from it the first enduring republic of the modern age. Last week, the Dutch showed us what free people could build in the empty place where King had stood. This week, we cross the North Sea to England, where the problem was different, and in some ways harder. The English were not trying to govern without a king. The king was still there, still on his throne, still is to this day, as a matter of fact, still claiming his crown by the gift of God. The English question was whether that king could be held, bound, limited, contained. by a law older and higher than his own will. And the man who pressed that question the hardest and armed the century that followed with words to fight it was a lawyer. This is the story of Sir Edward Coke and of the idea he, more than any other single man to forge, that the law stands above the king. It is the story of what the common law was and of the myth of the ancient Constitution, a magnificent argument that was very largely false and did enormous good anyway. It is the story of the great cases and of the petition of right and of a single phrase that nearly undid all of it. And as always, in this series, it is an honest story, because the history Coke championed will not survive a modern scholar's scrutiny. And the man himself, before he was the great defender of English liberty, was one of the most ferocious prosecutors the Crown ever employed. We will hold both the contribution and the failure in view and let neither erase the other. As always, the podcast expands upon themes of the article, brings in additional primary sources, and addresses complexities the written format cannot fully explore. So, are you ready? Let us begin.
Welcome to the Consequential Actions podcast. Here we ask a simple question of the history and the actions that have shaped our lives.
Did this leave us more free or more governed? Because what we do not know can be used to govern us.
And what we choose to ignore always will.
To understand why a single sentence from a judge could threaten a king, you have to first understand what the common law was. Because it is a genuinely strange thing, and its strangeness is the source of all its power. The phrase is so familiar to us now that we have stopped hearing it, common law. But to the 17th century English mind, it named something specific, and by the standards of the age, peculiar. Its own practitioners described it as a law no one had made, law that was found rather than commanded. That is the heart of everything. Set that against what was happening on the continent, and you see how odd it was. Across Europe, the prestige language of law was increasingly the civil law, the great inherited body of Roman jurisprudence gathered and systematized in the 6th century under the Emperor Justinian, and then revived in the medieval universities where it was studied as a rational science and organized into comprehensive written text. The contrast is easy to overstate, and this series did not deal in caricatures. The continent was never governed by Roman law alone. Local and customary and feudal law ran everywhere beneath the learned tradition. But the civil law carried an animating tendency that the English common lawyers deeply distrusted. It treated law as a system to be reasoned out and written down, and located the ultimate force of law in the will of whoever held legitimate authority to promulgate it. Law, on that view, was in the end the act of sovereign will. Somebody made it. The English common law leaned hard the other way. Its lawyers understood it not as the command of a sovereign, but as the accumulated custom of the realm, discovered and declared by judges as they decided actual cases, one after another, across centuries. Its authority came, on this account, not from any single lawgiver, but from continuity, from the claim that a rule had been followed time out of mind, beyond the memory of any living person, and it had proved itself simply by surviving. The judge did not invent the law. He remembered it. Now let's stop and clarify, because this series does not only trade a good story for a true one, and this picture, beautiful as it is not the whole truth. The common law did not well up untouched from the private customs of the English people. It grew through the king's own courts. It grew through the royal writs that controlled how a plaintiff even got into those courts. It grew through statutes and through the machinery of enforcement and through the constant competition of rival jurisdictions. A whole system with the Crown's own institutions sitting at its center. And the judges who declared the custom also selected it and shaped it and wrote it down and enforced it, which molded its content as surely as any act of remembering ever could. The lawyer's picture of a law that no one had made was a self-portrait, and it was a partial one. But it was a self-portrait with enormous consequences, because a body of law understood as discovered rather than decreed can present itself as belonging to no one and binding on everyone, including the king. This is the idea behind Coke's famous phrase, artificial reason. When he told James that the law was not natural reason, but artificial reason, he did not mean it that it was fake or artificial in our modern sense. He meant that it was a craft, a specialized kind of rationality, built up over generations by men trained in a discipline, refined case by case, holding within it the sifted wisdom of countless prior decisions. A brilliant king might reason as sharply as any lawyer about a fresh problem, but he could not reason his way to what the law of England actually was, because that knowledge did not live in raw intelligence. It lived in the long training of the common law mind. The law, Coke wrote, was an artificial perfection of reason gotten by long study, observation, and experience, and not by any man's natural reason alone. There's a genuine tension hidden inside this beautiful idea, and let's not smooth it over. We are going to need it at the end of this episode when the skeptic gets his turn. A body of law that is discovered rather than commanded can present itself as standing above everyone, above even the king. That is its power. But a body of law whose true content is known only to the initiated also places enormous authority in the hands of those initiates. The judges, the lawyers, the single caste of trained men who alone can say what in memoriam custom actually requires. Coke's doctrine set the law above the king. It also, and this is not an accident, set the men of Coke's own profession very near the top. The essential point holds. In England, there existed a body of law that its practitioners held to be immemorial, independent of any identifiable royal grant, and binding on the monarchy itself. It was the perfect raw material for anyone who wished to argue that a king's power had limits. And in the opening decades of the 17th century, England acquired a run of kings who insisted, with the full force of God's own authority behind them, that it did not. The common lawyers had a name for the deep structure they believed lay beneath their inherited custom. They called it ancient constitution. The idea was breathtaking in its reach. England, they held, possessed a fundamental frame of government and liberty that reached back beyond the Norman conquest of 1066, back beyond written record, into a Saxon antiquity of free men governing themselves under law. And on this account, the great landmarks of English liberty were not innovations at all. They were confirmations, restatements of rights the English always held. Magna Carta, on this reading, had not granted the liberties of Englishmen in 1215. It had merely written down, under baronial pressure, at the point of a sword, what was already theirs by immemorial right. It was a magnificent argument, and it was, in its literal historical claims, very largely false. There was no unbroken Saxon constitution stretching back into the midst of time. The Norman conquest was a genuine rupture, an armed seizure that installed a new ruling class and a new order of landholding on top of the old one. English law had changed enormously across the centuries. It had grown and mutated and absorbed foreign elements, and had been shaped again and again by the very kings the common lawyers now wished to bind with it. The picture of an ancient, fixed, unchanging law that merely surfaced from time to time in documents like the Magna Carta, that picture was a myth. And modern scholarship has known it to be a myth for a very long time. We reckon with that falseness directly, but before we let the myth go, notice what the myth accomplished. By locating the liberties of Englishmen in an immemorial past rather than a revocable royal grant, the ancient constitution placed those liberties beyond the king's reach. Think about the logic of it. A king cannot revoke what he never granted. If the rights of the subject did not originate from the king's gift, if they were older than the crown itself, inherited from a free Saxon past no monarch had authored, then no reigning king could claim to have created them. and no reigning king could claim the power to take them away. The historical fiction did real constitutional work. It took liberties that were, in fact, hard-won and contingent and revisable, and it converted them into liberties that felt permanent and inherited and untouchable. And a right that people believe to be ancient and untouchable is a right they will defend as their own. The story was false. The loyalty it produced was entirely real. And that loyalty guarded English liberty for centuries. Coke was the supreme master of this argument, and he was about to deploy it against a king who had come to England armed with an argument of his own. Because James I did not arrive in England as a blank slate for Coke to write on, he arrived as the author of his own political theory. And it was the exact mirror image of Coke's. James believed in the divine right of kings, and he had written it out plainly years before he ever reached England, in a book called The True Law of Free Monarchies. The doctrine was this: that kings derive their authority directly from God, and they answer to God alone, and that resistance to a lawful king is therefore not merely rebellion. It is something close to sacrilege, a sin against the divine order itself. On this view, the king was the ultimate source of public authority in the realm, and he stood beyond the coercive judgment of his subjects and beyond the reach of his own ordinary courts. Now, let's be fair to James here. Defense before critique, and the fair statement of his position is stronger than the caricature. James did not claim the right to be a tyrant. He held, and he wrote at length, that a good king should govern according to his established laws and should conform his own conduct to them. And he distinguished the true king from the tyrant carefully and deliberately. The king was bound in conscience and in the duty of his office to rule lawfully, and a wise king would. But, and this is a whole other matter, no earthly subject could sit in judgment over him or compel him as a superior compels an inferior. The prerogative, the reserve of sovereign authority inherent in the crown, was his to exercise as necessity, as his own judgment required. And so, to tell the king that he stood under the law, in the sense of being answerable to his own courts, was quite literally, in James's understanding, to approach treason, because it denied the divine origin of his office. So here what we actually have here. We do not simply have a contest between a good judge who loved liberty and a bad king who loved tyranny. That was the caricature. What we have is a collision between two serious and coherent theories of where public authority comes from, how far it reaches, and this is the hardest part: who gets the final word on where its limits fall. James and Coke actually agreed on a great deal. They both praised lawful government. They both said a good king should rule through established law. What they could not reconcile was the question underneath the agreement: whether the law's limits on the king were binding in any way a court could actually enforce, and who possessed the final authority to say where those limits ran. On James's account, the king stood beyond the coercive judgment of his own courts, the fountain from which all public authority flowed. On Coke's account, the king was contained by a law that the courts themselves were entitled to declare against him. The 17th century in England was, at its constitutional core, the working out of that single collision, through argument, through the courts, through parliament, and finally, through civil war, and the execution of one king, and a generation later, the deposition of another. Coke did not live to see the worst of it, but he supplied much of the ammunition, and he fired the opening rounds himself. Those opening rounds came as a series of cases, each one narrow in what it actually held and vast in what it implied. And that gap between the narrow holding and the vast implication is exactly how constitutional law is built. The first was the confrontation we opened with, the case of Prohibitions, reported under 1607. Its holding was narrow in form. The king could not personally take an ordinary case out of the courts and decide it himself, because judging required the trained, artificial reason of the law. That is a modest-sounding rule, but follow its implication. If the king could not personally exercise the judicial power, then the judicial power was simply not an extension of the royal will. It belonged to the law and to the courts that served the law. The king was one thing, the administration of justice was another, and the second did not simply fall under the decree of the first. Then, in 1610, came the case of proclamations. James had been making heavy use of royal proclamations as an instrument of government, governing by decree. In today's term, we would call it executive order. In effect, and the question is how far that power reached, he had moved to prohibit the building in London and to forbid the making of starch from wheat, and to make the violation of these proclamations a punishable offense. Now, some of this was not in dispute. A proclamation could lawfully announce the existing law or enforce a settled prerogative the crown already possessed. That was fine. The question the judges were actually asked was sharper. Could the king, by proclamation alone, by his own decree with no parliament involved, create a new offense? Could he make an act a crime that had not been a crime the day before? Coke, after consulting his fellow judges, delivered the answer. The king could not. The king, by his proclamation, could not change any part of the common law or the statute law or the customs of the realm. He could not, by his own decree, make a thing unlawful that the law had left lawful. And then the sentence. The king hath no prerogative, but that which the law of the land allows him. Now, I have to ask you to hear that sentence in the way 1610 heard it, and not for the way 4 centuries of hindsight has taught us to hear it. Because in its own moment, that was not a settled statement of the law. It was a contested assertion. It was thrown down by a judge who was himself one of the country's foremost theorists of the ancient Constitution, and it was very far from universally accepted. The opinion did not end the crown's use of proclamations. Its standing as a general limit on the prerogative stayed in dispute for decades. Later ages would treat Coke's line as bedrock, as if it has always been the law, but in its own moment, it was a gauntlet being thrown down. Not a description of the things as they indisputably stood, but a challenge, naming the exact question on which the whole century would turn. Does the crown possess reserves of power outside and above the law? Can he use that power to be drawn on when the king judges it necessary? Or is the scope of every prerogative ultimately defined by law, so that where the law is silent or contrary, the king simply has no power at all? Coke had given his answer, the Stuarts had given theirs, and the distance between those two answers was the distance to a battlefield. Coke pressed the same principle down into the ordinary life of the ordinary subject too, not just in the high politics of prerogative. A few years earlier, in Semayne's case of 1604, he had reported the resolution that would travel further in the popular imagination than anything else he ever touched. That the house of every one is to him as his castle and fortress, as well for his defense against injury and violence as for his repose. His home is his castle. Now again, be precise. The protection was legally conditioned, not absolute. The very same case held that an officer executing lawful process could break down the door, but only after he had announced his authority and had been refused. And the immediate question was the narrow one of when a sheriff could force his own entry. But the principle Coke drew from it was broad, and it was unforgettable. The king's officers could not cross a subject's threshold at their pleasure. The law drew a line at the door of the humblest dwelling in England, and it required even the crown's own agents to justify it before passing it. And that one is going to sail across an ocean. A century and a half later, American colonists, furious at the writs of assistance, the broad general search warrants that let royal customs officers hunt for smuggled goods without naming any place or any subject, that would reach back and take up Coke's castle principle. And it would become part of the common law background against which a young republic would one day write its Fourth Amendment. The line the law drew at an English door in the early 1600s became part of the line the law draws at the American door still today. Every week on Self-Evident, we go looking for the same thing, the moment an idea about human freedom first entered the world, and the reason why it still matters to you right now. Here's how the week works, and starting now, there is something new. It begins before the week even starts. The Sunday before, we publish a written piece on our website, the deep version, fully sourced, for the reader who wants the whole argument on the page. That is where the week is anchored. Then on Saturday, we tell the story, the thinker, the document, the turning point, the history itself. From the ancient world to the founding, that is our historical episode. On Tuesday, we bring it home. We take that piece of history and we hold it against a debate happening in America today. Because none of this is dead, every one of these ideas is still being fought over. That is our contemporary Part B episode. And now, on Thursdays, we'll be adding a third voice to the week. We're opening the conversation up. For several of the weeks remaining in this series, the week will close with an interview, a real conversation with someone who lives inside that week's theme. Some weeks that will be a politician making the case from inside the arena. Some weeks a historian who has spent a career in the sources we are only visiting. An economist to sharpen the argument about markets and money and power. A business person who feels the weight of policy in a way the rest of us only read about. And a host of liberty-minded individuals just like you, just like me, who have thought hard about what it means to be free. Here's why this matters. History can feel like it happened to other people a long time ago. It did not. The fight over who holds power, whether you are free or governed, is the same fight. It just wears different clothes in every century. When you hear someone living a fight today talk about the thinker who started it 400 years ago, the whole thing comes alive. The article gives you the depth, the history gives you the roots, the application shows you the stakes, and the interview puts a living face on it all. So join us, read it, then watch it. Saturday, Tuesday, and now Thursday. Every week, one question runs underneath it all. Did this leave us more free or more governed? Let us go find out together. The most famous words Coke ever wrote, and the most disputed, come from a case about a doctor. Thomas Bonham had earned a doctorate in medicine from Cambridge and set up practice in London. The College of Physicians of London claimed that its charter and its confirming statutes gave it the power to license physicians in the city and to fine and imprison anyone who practiced without its approval. It ordered Bonham to stop. He refused. He was fined. He refused to pay and he was imprisoned, and he sued for false imprisonment. The case came before Coke in the Court of Common Pleas in 1610. Coke found for the doctor, and he got there by more than one road. He first read the college's statutes narrowly, construing their power to punish as reaching genuine malpractice that endangered patients, rather than the mere practice of medicine without a license. But then he turned to a maxim of natural justice as old as law itself, that no man may be a judge in his own cause, and here the college had a problem. Because the college kept half of every fine it imposed, which meant it stood to profit from its own convictions. It was prosecutor and judge and financially interested party all at once, ruling on cases which had a direct stake in the outcome. And a statute that made a body the judge in its own cause, Coke reasoned, ran against a principle so fundamental that the common law would strain hard against letting it stand. And then he wrote the sentence that would outlive him by 400 years. It appears in our books that in many cases the common law will control acts of parliament and sometimes adjudge them to be utterly void. For when an act of parliament is against common right and reason, or repugnant or impossible to be performed, the common law will control it and adjudge such act to be void. Consider what that sentence appears to say. On its face, it goes well beyond binding the king. It can be read as a claim that even Parliament, the kings, the lords, and the commons altogether, the highest lawmaking authority in the entire realm, could not enact a statute so contrary to fundamental right that the courts would enforce it, and that the judges, the men of artificial reason, would be the ones who decided when a statute had crossed that line. And whether Coke actually meant it that broadly is a question that 4 centuries of brilliant readers have been completely unable to agree on. So thus, briefly, here are the honest opinions. One reading, associated with legal historian Samuel Thorne, takes the passage modestly. Coke was describing a rule of interpretation, not a power of nullification. When a statute produced an absurd result, the courts would control it by reading it sensibly, not by striking it down. A bolder reading, argued most forcefully by Raoul Berger, holds that Coke did something more. that the statute's words were clear, its only application unjust, and Coke voided it rather than merely interpreting it, anticipating, however dimly, the thing we would later call judicial review. Now, between those two lines sits the careful reconstruction of Charles Grey and the recent restrained reassessment of Geoffrey Goldsworthy, who situates the words inside Coke's own legal reasoning and disputes the strong reading. And the honest position is that the dispute simply cannot be settled from the text alone. Coke himself may never have drawn the distinction as sharply as later readers have needed him to. But here's what's not in dispute. What is not in dispute is what happened to those words next, and that the story belongs to a later article and a later country, because when American colonists went looking a century and a half on for authority to argue that even Parliament's acts could be void against a higher law, they found Lord Coke's sentence, and they did not trouble themselves much over the narrow reading. In Coke's own England, the dictum never did mature into a settled power to strike down acts of Parliament, as English practice settled more and more firmly on the supremacy of Parliament. The idea found no lasting home there, but it crossed the ocean and found one. But I've run ahead a little bit, so I need to bring us back into Coke's own life, because his single most consequential act came near the very end of it, and it came not from the bench, but from the floor of the House of Commons. By 1628, Coke was in his mid-70s. He had been stripped of his judgeships years before. He was a veteran of a decade of parliamentary combat against the crown. Old James had died in 1625, and his son now wore the crown, Charles I. And Charles held his father's exact theory of kingship, with even less of his father's caution. Charles needed money for war. Parliament would not grant it on his terms, so Charles turned to methods that treated the subject's property and liberty as mere instruments of royal necessity. He imposed the forced loan, a compulsory levy demanded from his wealthier subjects under the name of a loan, though no Parliament had ever voted for it. And those who refused to pay, he imprisoned. In 1627, 5 of those imprisoned knights sought their freedom through the most ancient protection the common law knew, the writ of Habeas Corpus. The writ that commands a jailer to produce his prisoner and show the lawful cause of the imprisonment. And the Crown's answer, when the case was demanded, was chilling in its simplicity. They were held, the Crown said, per speciale mandatum domini regis, by the special command of the king. And no further cause needed to be shown. The court declined to grant the men bail. Technically, the ruling was narrow, an intermediate refusal rather than a final judgment blessing unlimited powers to imprison. The judges reserved the deeper question rather than settling it. The practical message was stark enough to freeze the blood of every man who believed the law stood above the king. 5 Englishmen sat in a prison on the king's bare word, no cause shown, and the courts had not to let them out. To Coke and to the men who thought as he did, this was intolerable. And when Parliament met in 1628, the old man set to make it impossible to ever happen again. The instrument was the Petition of Right, one of the great documents in the whole history of Anglo-American liberty, and it named 4 grievances, and it demanded that each one cease. No taxation, no forced loan, no benevolence, nothing, without the consent of Parliament. No imprisonment without cause shown, that no Englishman could ever again be jailed on the naked command of the Crown. No billeting of soldiers in private homes against the owner's will. And no martial law imposed in time of peace. Each was a precise answer to a precise abuse. And together they amounted to a plain and deliberate reassertion that the Crown's power ran only so far as the law allowed and not 1 inch further. And then came the most dangerous moment of it all. Because when the petition went up to the House of Lords, the Lords proposed to add a small saving clause, a proviso that nothing in the petition should be construed to injure the sovereign power of the Crown. Just a few words, and it would have been fatal, because they would have preserved the exact thing the whole document existed to destroy. A reserve of royal authority standing above the law. If the Crown kept a sovereign power above the law, then every single liberty the petition had just named was held, after all, only at the Crown's sufferance. And the old man rose against it. and he saw the trap with a perfect and terrible clarity. To add those words, Coke argued, would weaken Magna Carta and would weaken every statute on which the subjects' liberties rested, because those statutes were absolute and they contained no saving of any sovereign power. To insert that phrase would now be to undermine the whole foundation of the whole law. And then the entire building must fall. Grant this, he warned, and by implication, you grant a sovereign power above all law. And the saving clause was dropped. Charles gave his formal assent to the petition on the 7th of June, 1628. The conflict was not resolved. Charles disputed the petition's force almost at once and narrowed and invaded its protections in the years of personal rule that followed. The quarrel did not end in 1628. It deepened until it ended some 20 years later, with the king's own head on a scaffold. Coke did not live to see it. In July of 1634, in the last months of his life, officials acting on royal orders came and seized the papers from his house and his chambers. Some were returned after Parliament intervened years later. Others, the scholarship suggests, were carried off and never seen again. Coke died that September at the age of 82, but the words he had already put into print were loose in the world, and they would not be recalled. The genuine contribution and the grave failure can inhabit the very same person at the very same time. We have said that in almost every episode that we've had so far. We hold both of them in view without letting either erase the other. And the reckoning Coke demands of us has two hard parts. The idea he championed rested on false history, and the man himself, for much of his career, was no friend at all to the liberties his old age is remembered for defending. And take the history first. The strong form of the ancient Constitution, the immemorial, unchanging English law, reaching back untouched to past the Norman conquest into free Saxon antiquity, was not true. Coke's account of a continuous fixed body of custom surviving unbroken across the centuries was an untenable history, pressed into service of a legal argument. Now, I do not say that he lied. There's no need to suppose that Coke knew it was false. The ancient Constitution was the shared inheritance of his whole profession, believed at least as much as it was deployed. But a myth honestly held is still a myth. A useful story and a true story are not the same thing. That is one of the recurring lessons of this entire series, and both facts hold here at once, without cancellation. The ancient Constitution did enormous good, and it was not real. And the falseness of it is the sharpest weapon the skeptic is about to pick up. The second hard part is the man. It's tempting to picture Sir Edward Coke as a lifelong tribune of liberty, standing against tyranny from his first breath to his last. Alas, he was nothing of the kind. Before he was ever the crown's great antagonist, he was the crown's great servant. As Attorney General under Elizabeth and then under James, he was prosecutor of a ferocity that genuinely appalls the modern conscience. At the treason trial of Sir Walter Raleigh in 1603, Coke, as the Crown's Attorney General, prosecuting, pressed a case that rested heavily on a written accusation by a man Raleigh was never allowed to confront or cross-examine. And he heaped upon the accused a stream of personal abuses so vicious it shocked even the hardened spectators of that age. He also prosecuted the surviving gunpowder plot conspirators in proceedings that relied upon pretrial examinations and confessions, including material extracted after Guy Fawkes had been tortured. And that gave the defendants none of the protections that we would now consider the bare minimum of a fair trial. No real defense counsel, no right to confront the witnesses against them, and now the plotters were genuinely guilty of a real and murderous conspiracy. The point has never been that they were prosecuted, the point is how. Those procedures sit in deep and uneasy tension with the Coke of later years. The Coke who told Parliament that no man could be imprisoned on the king's bare word, the man who became the great enemy of arbitrary power had, as the Crown's own advocate, helped send men to their deaths in proceedings that offered a fraction of the safeguards his old age is honored for defending. Both things are true, and the honest account has to hold both. It would be a lie to enlist Coke as a plaster saint of liberty. And it would be an equal and opposite lie to dismiss the whole of his contribution because the man was flawed and the history was false. The fair judgment is harder than either and far more interesting. A ferocious crown prosecutor working with a legend about the Saxon past, a legend that could not survive a modern scholar's scrutiny for an afternoon, nonetheless forged the intellectual weapons that outlasted his own inconsistencies and outlasted his own errors. Weapons that free people would take up long after his death, against the very kind of power that Coke himself had once served so ruthlessly. The principle proved larger than the man who shaped it. That is not a reason to excuse what must be named. It is a reason to take the principle seriously on its own terms, apart from the imperfect and sometimes bloody hands that first held it. And now we're back to the part of the episode where I give you the strongest case against my argument. Against the account I've given you, a serious reader can raise at least 3 objections, and each one we will give their full due. The first objection is the one the honest reckoning has already half conceded. It is the entire edifice rests on an invented history. If the ancient Constitution was a myth, ipso facto, if there was no immemorial Saxon liberty, no unbroken chain of fundamental law predating the conquest, then everything Coke built stands upon false foundation. The common lawyers claimed authority for the subjects' liberties precisely by insisting those liberties did not come from a revocable royal grant, and that insistence rested on historical claims that were simply untrue. Strip the false history away, the skeptic says, and what is left is not a discovered constitution at all, but a constructed one, dressed up in some borrowed antiquity to lend it a weight that it had not actually earned. A liberty that has to lie about its own origins in order to command respect is standing on unstable ground, and Coke's method, reading the conclusion he wanted back into an imaginary past, is exactly the kind of motivated history that a serious mind ought to distrust on sight. The second objection runs the opposite way, and it targets the deepest single sentence in the episode. On the strongest reading of Bonham's case, the reading America would later seize, Coke set not just the king, but the highest lawmaking authority in the realm beneath a higher standard of right, to be enforced by judges. And the skeptic asks, is that liberty, or is it just a different master? Because a principle that lets unelected judges strike down the acts of an elected legislature on the ground that those acts offend common right and reason places enormous and legally unaccountable power in the hands of the judges who get to decide what common right and reason require. Coke set the law above the king, but on this reading, he set the interpreters of the law, the lawyers, the judges, the caste, very near the top, and it's not obvious, the skeptic presses, that a free people has gained anything at all when it trades the arbitrary will of one king for the arbitrary will of a handful of unelected men in robes. And the third objection is the sharpest one, because it goes after the motive. Coke, this objection holds, was not defending abstract liberty at all. He was defending the common law courts, the common law profession, and his own place at the summit of it, against every rival center of power that threatened it. The church courts, the court of the chancery, the prerogative courts, and above all, the crown, which threatened the jurisdiction of the very bench that Coke sat on. His grand principle that the law stood above the king conveniently placed the interpreters of that law, the judges, the lawyers, and Coke himself above the king as well. That famous artificial reason, which only the trained lawyer could wield, that was not a neutral description of a craft. It was the claim of professional monopoly, an assertion that only one particular caste and no one else could say what the law required, and that even the sovereign had to bow to their expertise. Read that way, the skeptic concludes, the whole magnificent struggle looks less like liberty against tyranny and more like one elite defending its turf against another. Okay, so let me answer them. So the first, yes, the history was false. I've already said so. Let's not take it back now to win this argument. But notice what does and does not follow from that. The falseness of the ancient Constitution's history does not make the liberties it protected false. The right not to be imprisoned on a ruler's bare word does not become worthless because the men who defended it told themselves a fairy tale about its Saxon origins. And this is the pattern the whole series keeps finding. A useful fiction can do genuine good, and the good outlives the exposure of the fiction. We no longer believe in the memorial Saxon Constitution. we still believe a king may not jail a man without cause. The scaffolding was false. The building it raised is real, and we live in it. To the second objection, the fear of government by judges. I concede that it names a permanent and unsolved problem, and we're not going to pretend otherwise. Placing a higher law above the legislature really does hand great power to whoever gets to interpret that higher law. That tension is real. It is with us to this day, and we will meet it head on in the liberty lens in a moment. But observe that the objection is not really an argument against Coke. It is an argument about a permanent trade-off in free government, one the American founders would inherit whole and argue about ferociously and never fully resolve. Coke did not create the dilemma. He was among the first to hand it forward. And to the third, the charge that Coke defended his caste and not liberty. Okay, again, I concede most of it because it is the truest of the three. The self-interest was real. The doctrine that set the law above the king did, in the very same motion, set the lawyers very high indeed, and Sir Edward Coke was not a disinterested party to that arrangement. But again, two things can be true at once. A principle can serve the interests of the man who advances it and still be sound. And it can still do good far beyond anything he intended. The judge's defense of their own jurisdiction happened, in this instance, to require the proposition that royal power had legal limits. And that proposition, whatever its grubby motives, became a load-bearing timber in the architecture of free government. History very rarely hands us pure motives. It much more often hands us mixed motives that happen to produce institutions with real liberty-protecting effects. The task is not to pretend that Coke was selfless. He was not. The task is to recognize that the thing he defended for partly self-serving reasons turned out to be worth defending, for reasons that had nothing to do with him at all. So let us now do that plain question the series always returns to, the liberty test. Did the thing leave people more free or more governed? And we'll apply it to the deepest idea of this whole episode. Coke's insistence on law older than any living ruler. A body of fundamental rules that the current rulers cannot simply make or unmake at their pleasure. What makes this genuinely hard, and it does not resolve cheaply, is that a fundamental law of that kind ties the hands of present power. That is the entire point of it. It says there are some things you may not do, no matter how badly you want, and no matter how sure you are that you are right, and no matter how large the majority standing behind you. And that cuts in two directions at once. And an honest person has to feel the pull of both. On the one side is the great guarantor of freedom, a right that a current majority cannot vote away, a right you can actually count on. The whole worth of fundamental protection is precisely that it does not bend to the passion of the moment, that it stands there, immovable, when the mob and the magistrate alike would very much like to move it. The Englishman who could not be jailed on the king's bare word was free in a way that a man dependent on the king's goodwill simply was not. Fundamental law is what turns a privilege into a right. But on the other side, and the skeptic was right to press this, a fundamental law that the current authority cannot override is also a constraint on self-government, because someone has to say what that higher law means. And when a court strikes down what an elected legislature has done in the name of a fundamental right, it has also, unavoidably, substituted the judgment of a few unelected interpreters for the judgment of the people's representatives. The very same immovability that protects your freedom from a hostile majority can also frustrate your liberty to govern yourself through that majority. Both of those things are true. They are true at the same time, and they do not cancel out. So here, an honest present-day question, and let's leave it genuinely open. When we place a right beyond the reach of ordinary politics, beyond the vote, beyond the legislature, in the keeping of the courts, are we protecting the people's freedom, or are we constraining the people's self-government? And the honest answer, the one Coke's whole inheritance points towards, is both, always both, at the same time. The question is never whether to accept that tension. A free society cannot escape it. The question is only where, on any given issue, to strike the balance between liberty that a fundamental law protects and the self-government that it necessarily limits. Coke did not solve that problem. No one has solved it since. He did something more useful than solving it. he handed it forward. Sharp and unresolved and honest to every free people that would come after him, including ours. The final measure of Coke is not what he meant, it is what he became. And in the American colonies, Sir Edward Coke became something very close to the schoolmaster of the Revolution. Not its only teacher, but one of the central authorities from whom the revolutionary generation learned its law. He had written 2 great bodies of work that carried his mind forward across the century and across the ocean. The reports gathered and expounded the cases, and the institutes, 4 massive volumes, the first of them a commentary on an older treatise on property law by a jurist named Littleton, set out to state the whole of English law in a form a student could actually learn from. And crucially, much of it was written in English rather than in the law French of the profession, which put it within the reach of a far wider readership. For well over a century, these works sat at the center of the legal education across the entire English-speaking world, and nowhere more than in the American colonies where, for many a young man reading the law, Coke was the first and most formidable authority he ever met. And the evidence of it is specific and is far more delightful than any blanket claim could be. Consider Thomas Jefferson, who prepared for the bar under the guidance of George Wythe, the Virginia lawyer often called the first law professor in America, the man who would one day sign the Declaration of Independence that his own pupil had drafted. Wythe set young Jefferson to reading Coke, and Jefferson found it perfectly miserable. In a letter to his friend John Page written on Christmas Day, 1762, the 19-year-old law student groaned that he simply could not get through Old Coke that winter, and then delivered a verdict that generations of law students have silently seconded ever since. I do wish, Jefferson wrote, that the devil had Old Coke, for I am sure I never was so tired of an old, dull scoundrel in my life. That's a little delicious detail, and it's an instructive one, because the man who would go on to write one of the most consequential sentences in the entire history of human liberty learned his law by slogging, cursing, bored to tears by candlelight in a Virginia winter through the dull and difficult pages of Sir Edward Coke. And Coke's defense of the rights of Englishmen became part of the very inheritance that Jefferson would one day turn against another king. And consider John Adams, who did not merely endure Coke, but wielded him like a blade. When Parliament passed the Stamp Act in 1765, Adams drafted a set of instructions that his own town of Braintree adopted and sent to its representative, and he grounded the colonial objection in the 2 oldest guarantees he could lay his hands on: Magna Carta's law of the land, of which Coke had become the great expositor, and the ancient maxim that no free man may be taxed without his consent. In newspaper essays, he wrote under the borrowed persona of a 17th century figure, and he urged his readers to recollect the old sage Coke. And in an argument before the governor and the council that December, Adams called the Stamp Act utterly void, and pointed to the judgment that an attempt to make the king's proclamation into law had itself been held void, which was an unmistakable allusion to Coke's own case of proclamation. The exact reasoning Coke had forged against a king's decree a century and a half before had become, in the hands of a Massachusetts lawyer, an argument against a parliament. And consider even those who barely cracked him open. Patrick Henry, the great Virginia orator, is a far less certain case. Jefferson later remembered him as having read law only briefly, though even that recollection is disputed by the surviving records. But how closely Henry ever read Coke, we honestly cannot say. But what a figure like Henry may illustrate is something the deeply trained lawyers do not: that the constitutional vocabulary of the common law had escaped the books entirely, that it had spread out into the wider political air, where even a man without Jefferson's or Adams' documented depth of legal reading could still draw on the deep conviction that Englishmen held rights the crown could not lawfully cross, that power itself answered to law, and that a free people might rightfully resist a government that broke its bounds. And that is the deepest measure of Coke's transmission. His volumes were part of the formal curriculum, yes. And generations of colonial lawyers learned their trade with him near the center of it. But the principles traveled further than the books ever did. They spread into the arguments of men who had studied him line by line and into the instincts of men who had barely opened him until the proposition that the king is under the law, Bracton's old maxim, carried by Coke to James at Whitehall, had become one of the deep and load-bearing threads of American constitutional argument. When the colonists insisted that Parliament could not tax them without their consent, that they could not be tried without juries, that their homes could not be searched on general warrants, they were reaching for an inherited legal language and adapting it to a new imperial crisis. That language was not the whole of what they drew on: natural rights, religious conscience, Republican theory, their charters, their own hard political experience. All of it ran alongside. But the vocabulary of the ancient Constitution and the common law was among the oldest and most familiar tools in their hands, and a Jacobean judge, dead a century and a half, had done more than almost anyone to shape it. Coke had taken the raw inheritance of the common law and forged it into a set of propositions that a free people could actually carry into battle. That the law stands above the king, that the crown has no prerogative beyond what the law allows it, that a subject may not be imprisoned on a ruler's bare word, nor taxed without the consent of Parliament, nor searched in his home at the state's pleasure, and that even the highest lawmaking authority in the land might somehow be measured against a deeper standard of right. He had wrapped those propositions in a myth about the Saxon past, and he had defended them at times with hands that were not clean. But the propositions outlasted the myth, and they outlived the man. And they crossed the ocean into the minds of people who would one day build a nation upon them. But Coke's Constitution looked backward. Its whole authority came from age, from custom, from the claim that these liberties had always existed and needed only to be remembered and confirmed. And that is a powerful argument. But it is a conservative one. It defends the subject's rights by appealing to what supposedly already was. And in the turbulent decades right after Coke's death, as England descended into civil war and the whole order was torn open, a more radical generation would seize the argument and press it much, much further. They would ask a more dangerous question. They would ask whether the liberties of a free people really rested only on their antiquity, on some half-imagined Saxon past, or on something truer and more universal than any inheritance. On natural right, on the consent of the governed, on the plain equality of men. To those radicals, the levelers, who pressed that question at the very moment the English world was being ripped apart, the series turns next. Next Saturday in episode 9, The Levelers, the most democratic voices of the English Civil War, who took the language of English liberty and turned it towards something Coke never intended, an argument not from the dust of the past, but from the natural equality of every man. Having watched Coke bind a king with the chains of an ancient constitution, we turn to the men who asked whether free people needed the ancient constitution at all. And this coming Tuesday, in our contemporary application episode, we take the inheritance of this hour, the idea of a fundamental law above the reach of ordinary power, and the hard, unresolved tension between the liberty it protects and the self-government it limits, and we hold it against our own moment. I am Jeff Kellick, and this has been episode 8 of Self-Evident, The Road to 1776 on the Consequential Actions podcast. If you have enjoyed this episode and want to follow the series, please subscribe to our Substack page at consequentialactions.com. There you'll find written articles on our previous series, such as the General Welfare Clause, the New Leviathan, and the Empire of Liberty. Also, subscribe to our YouTube channel at Consequential Actions Podcast for video versions of all podcast episodes, as well as some exclusives. And follow me on X at jkellick for updates, discussion, and announcements. We continue to post articles and welcome your participation. Till then, have a great day.